I can see if you had an animal trap, perhaps, and somebody stepped in it, you might have some liability there. Even though it's not willful or malicious, it is intentional, and it is something that's not a natural formation. We get into parks, recreational areas, things like that. Things tend to get a little bit different with waivers. As I said at the beginning, having a waiver is better than not having one. We get the problems with the minors. A parent can never waive a minor's right to sue. We've tried to get around that a number of times, but you can never waive the right. The defendant's always on the hook. If the fee is charged, as a general rule, the waiver is going to be void. Now, interestingly enough, I'm sure anytime you go to the amusement park, park your car or something like that, you see on the back of your ticket, of course, there's a little miniature liability waiver that no one ever reads or can read. However, in New York State, under the General Obligations Law, which is the black book that's sitting up here, a owner of a swimming pool, a gym, and a place of public recreation or amusement, whatever that may be, cannot enforce a liability waiver if a fee is charged. Specifically to horse farms, what is public recreation? Well, under that general obligations law, the court held in 1992 that the release given by the horse rider to the riding stable didn't hold up, struck it down. Public recreation is trail riding on a horse. You're open to the public, you're charging a fee. Where it gets in a gray area for you if you're running a instructional stable or an arena. There's instructional versus recreational. Where's that line drawn? That gets into a gray area. If you're using a recreational facility for an instruction purpose, your waiver will probably be upheld. So if you're using the swimming pool to instruct people in lifeguarding, they all sign waivers, somebody drowns, your waiver will probably be okay and protect you. Similarly to the horse riding scenario, if you're instructing people in horse riding, instructing them in jumping maybe in an internal arena, the waiver would probably hold up because it's instructional in nature. That is getting in a gray area though, because people do that activity for recreation, whereas the lifeguarding is not really a recreational activity. So it's a gray area, it's a difference. This is why you're always going to want to have good waiver. Yeah.
Trail riding. We run riding school, teach riding lessons, instruction, jumping. At the end of that session, they may choose to go for a walk on the trails.
Okay.
Is that considered a trail ride, or is that considered pulling the horses down? How do we?
So they're walking the horses?
They're walking the horses, but they're walking them outside the arena, into the open hay fields, coming back 20 minutes later.
Well, as a defendant, I call it a lark and a frolic. I don't know. Kevin trail rides, walking the horse as opposed to riding it?
I mean, how do you define a trail ride? I mean, in my definition of a trail ride, it's me on a horse with 20 other people, and there's a lead horse that I'm paying to go for that hour and a half.
That's called a guided trail ride. That's
A guided trail ride, okay.
More importantly, would the insurance apply if they're walking the horse, Kevin, on the trail ride, on the trail choose forever?
But
You're talking riding at the walk, you're not talking leading the horse, correct?
I'm talking riding at the walk, but they're paying a fee for.
Oh, so actually riding the horse, not leading the horse.
They're riding the horse, yes. They're
Oh,
riding
okay.
the horse, they just took a lesson.
Yeah, it's a
The horse-
trail ride, sure.
The horse now that the horse is being cooled down, okay, after 20-minute, 30-minute exercise. But they're not doing it inside the arena, they're not doing it inside the ring, they're not doing it inside.
Yeah, okay.
They're doing it outside. It could be on the driveway, it could be down the side of the paddocks, it could be anywhere on the property.
I'd say a very good argument could be made that that's a trail ride, and unless you have the specific insurance for trail riding, you may not have coverage.
No, that wouldn't be considered.
You don't think so, Kevin? Okay.
That would still come under the instruction. It's part of the lesson, it's part of the time spent
that as part of the instruction.
Yeah, that would just be part of, that'd be part of, instruction.
Okay.
As long as you have the instruction covered correctly in the policy, you'd be safe.
And Kevin, you think that would fall under the instruction portion of the policy, not the trail riding?
Excuse me?
You think that would fall under the instruction portion of the insurance policy?
That wouldn't be construed as the definition of a guided trail ride. A guided trail ride is what the gentleman mentioned. You're gonna go someplace, they're gonna give you a horse, it's gonna be a lead guide, they're gonna take you out, you're gonna pay for an hour, hour and a half, that's a guided trail ride, that's a whole other situation.
Yeah, it's,
Would an instruction imply that there's an instructor there?
that's what I would think as a plaintiff's lawyer, but, certainly opinions made, it's a tough question. It's a gray area for me. And Kevin's certainly the insurance expert in this area, and
Well,
he may be right as well.
one distinguishing characteristic is we don't have a facility that you can come on and pay me to go on a trail ride. We don't allow that.
Okay.
Okay, we are strictly a riding instruction facility. You wanna take a lesson, you come to us. You wanna go on a trail ride, you go to my neighbor. You know?
Okay.
So trail riding is not part of our environment, but the term trail riding, as part of the everyday language, people use it.
Mhm.
You know, after a riding lesson, we spend 10 minutes going for a trail ride. They're going on a path, you know,
Path around the barn,
yeah, path
field or
around the
something.
field area, around the property, or wherever, you know.
Yeah.
You're fine in terms of your insurance. The thing that you're missing is the other one is a totally separate activity. A guided trail ride is gonna be very different than what you're offering your clients. And just going on a trail ride with a horse is different than a guided trail ride. It's not like going up in the Adirondacks and going to Bennett's or going to Circle B and, you get there and they show you a video about how to ride a horse and they throw you up there and see if you can stay on. And once they determine that, they'll let you leave the corral and you go for a ride. That's a guided trail ride. Whether you know anything about a horse or not, they'll take you out.
Which is
I'd
the
rather
best lawyers
usually
putting
get
me in
you
cold
home.
sweats. But yeah, I mean, it's looking at it legally. I don't care what you call it.
Right.
It's going to be the action. It's going to be what we can come up with is negligence or not negligence. And as long as you have the coverage for it, go for it. Just make sure you have the coverage. Like I said, you can be sued for anything.
Yeah.
A question on waivers. I don't know if I'm reading it correctly on this, but if you charge for horseback riding lesson, does that negate the waiver that we signed?
Most likely yes. But have them sign it anyway. Because the first thing when you get sued and you bring me the complaint is I'm going to raise the defense of release and waiver. Also, by psychologically someone signing a waiver, they think they might not be able to sue you. If they never sue you, you're in the clear. It's more about a psychological thing than a legal thing. We'll let that.
The important thing with the waiver is, as Jonathan mentioned earlier, is that they're correct for the state you're in and they're drafted correctly. If they're not drafted correctly,
Yeah.
then it's useless.
There are more ways around a waiver that we spend for institutional and business folks. We spend a tremendous amount of time very carefully crafting our waivers. Things like construction contracts, other types of contracts where you've got all these different rules in the general obligations law. You've got to have it just right for the courts not to toss it.
But at the end of the day, it's still not the issue of negligence.
It is.
At the end of the day, that's really what it comes down to. You can have the most solid waiver going, but if you did something that is considered not to be proven, you're gonna be found negligent.
Maybe. Unless you can get out early on a motion for summary judgment.
Do the helmet laws and all that apply to wagon rides as well as your horseback riding?
I don't know. I can tell you from going around to the local farm fest with a 3-year-old and going on the hay rides, it's great fun, but as a defense attorney, it gives me cold chills.
That's the question I have.
That's what we do.
That's a great question.
We do that. We have people, in one night, we may have 200 people
Yeah.
take rides. So each one has to sign a waiver.
Oh, absolutely.
How are you gonna do that?
What,
These people go on for one ride.
here's a great thing a client of mine does. She has the waiver, she has 20 or 30 signature lines on that waiver, and she's got it bound in a book. Everybody signs on the signature line. You're not signing individual waivers. Everybody signing, you turn the page, you got another 30 with the waiver printed. She does it, everybody comes on the property, the book's at the front door, you sign the waiver. It doesn't matter if you signed the waiver before, you sign the waiver again.
We don't give them on our own property. We go somewhere else.
Oh.
We give them. We go to towns, we go to villages.
Do you have contracts with the town or village?
We contacted the town, the village that we were in. The village said, don't worry about it. We have our own insurance that will cover you. We also carry our own insurance.
Uh-huh.
Now what happens there? You get a contract?
If you're doing it at a village event,
Village event.
as a plaintiff's lawyer, I'm thinking cha-ching, and I'm gonna be aiming for village.
Okay.
Make sure you get to it.
Yeah,
Um,
but you're gonna go to the bigger.
Absolutely, absolutely.
Well, you go for both, right?
Well, you go for both, but,
Just so everybody inside.
yeah, my eyesight's gonna be on the village in that case. As soon as I find out that I was a village event, if I didn't know that before, I'm amending my complaint and bringing them into the party, absolutely. It's tough with municipalities, they're not gonna wanna waive negligence. You know, it's, he who has the gold makes the rules, and, but they are usually very well insured, or even better, self-insured.
They are catch 22, right?
Yeah.
So
Sa-
I know that part also.
Yep.
But
Yeah, try to have something in place that each party is gonna provide their own insurance. You know, each party is going to assume the risk for their own negligence. You know, if you have that agreement, usually you can get the municipality to sign a mutual negligence type of contract, I like to call it. Then the plaintiff's gonna be in a position of proving who was negligent for what. Well, did the municipality not fill the pothole, or was the, you know, the tire too low on air? So you've got some issues where you can start pointing fingers back at the municipality. Of course, the flip side of that is they can point a finger at you. But having something in writing that gives you that ability is certainly better than not having it.